Hi, ladies and gentlemen. We are back with the SAPI IP Business Talks. And today we have a fascinating topic. It's about AI-based court decision analysis. So that is really something we would like to dig in, to make a deep dive in that topic. And I have an expert with me from Berlin who will explain us that. It's Til Bußmann Welsch. Hello, Til, good that you are here. And first of all, some housekeeping rules. We are live, ladies and gentlemen. That means we are happy to get from the audience your comments, your questions to the discussion, and then we can integrate that. I will pick it up and bring it in the show to talk about that. And when we talk about AI-based code decision analysis, for the moment, globally, I cannot think about somebody else than Til, because he's really an expert, and to a certain extent, he invented that. At least here in Germany or in Europe, it's an absolutely groundbreaking work which he's doing. So first of all, Til, thank you very much for joining us today. You're located in Berlin, and my first question is to all of my guests the same. How did you came into that strange field of IP?
Yeah, Alex. Thanks first of all for having me here. It's a great pleasure to be part of this live talk on LinkedIn. That's a longer story, and I think it dates back like 10 years probably, like to 2015. Of course, I have a legal background. Studied law in Germany, and in my second semester, like the second wave of legal tech came up at that point in time, with like rule-based systems, automating stuff, and a lot of bullshit bingo articles also happened there saying, okay, it's the end of lawyers, Richard Susskind. And that was in my second semester. I was like, okay, is it useless what I'm doing? But I was...
and even without AI at that time.
Well, I mean, back then we called it
useless without AI.
Or it was a different understanding of AI that we had at that point in time. And I was wondering, is that really true? And then I came behind it. Okay, we can automate some stuff, but it's not that groundbreaking in the end that we lose our jobs in the end. So I decided, okay, continue my legal work, but I wanted to be in the forefront of this development. And during my studies, I got to know Frederick Tolai in a boutique that we worked together with. And he was a bit further in the legal education. He was already a lawyer. And we said, okay, we're going to go in this topic of legal tech, like generally. And we said, okay, we're going to sit down 6 months, decide which sector do you want to tackle. And I started a PhD aside of that, supervised by Stefan Breinbach and Dirk Heckmann, also two important figures in that field in Germany. And I decided to do my PhD on judge behavior analytics. So which external factors influence judicial behavior? And then I realized, okay, that's a topic that is relevant in a lot of countries, US, like even Russia, even China. But in Europe, especially in Germany, it's not a topic that is looked into deeply due to several reasons. And then we thought, okay, let's go into this topic. We've seen that there are also databases working in this area, analyzing, okay, how often did a specific judge decide a specific manner, with outcome, which arguments occur in comparable cases, how often, which cases are successful, which are not. And we thought, okay, maybe we can build a database based upon that. And we started this journey in like 2021. And then, of course, at the end of 2022, Gen AI happened, right? That's our new understanding of AI. And we did a pivot there. And then we thought, okay, which field is most likely to be adaptive to this new shift in AI? And we thought IP law in the legal domain, that's it. Because these people, they are used to work with new technologies, right? If you look on design law, on patent law, it's pretty obvious. And it was very fun then talking to these people and working with them and developing new products because they were very open-minded. So it's actually, if you want to sum it up, it's the openness of this field of law and the creativity of this field of law that led us to start with this IP law field. Yeah.
Yeah, thank you. That's fascinating. And for all of you who want to learn more and to dig deeper, beside of our discussion today, Till has already a Dplex page, and you find here lots of background information to his approach in that field. So to analysis the decisions of courts and to use for that AI. So first of all, you developed. We can see it on your screen. So you founded Anita. So is Anita a company? Is it a product? So that's the first thing. When we talk about, let's say, the legal landscape and the usage of digital tools, and what is your vision on that? So you said you choose IP because it is to a certain extent open to new technologies. To be honest, I'm not that sure about that, because when you talk with IP guys, they will always explain you that they are extremely conservative. But I agree that some of them are quite open, and we see that at the moment in patent drafting, for example, and also using AI tools for patent search, so that there is a change. But in general, what do you think are the, let's say, general opportunities for legal experts, in this case IP experts, in the digital transformation, and how do you think, Naya, should they adapt to a certain extent their working styles, how the processes? What is your, on the one side, experience, and on the other side, expectation on that?
So I'm gonna start with your question relating Anita, because there's also like a journey how we came to this, because we started with a different name. Actually, it was Your Crowd in the beginning, because we do data analysis, and of course, to do data analysis, you need data. And we focus on court decisions, and this is a rare data source because only 1% of these data is made public due to several reasons, again. And then we said, okay, we have these public resources, but we also have law firm data that we can use. These guys also have these core data. So we said we form a legal crowd, a Your Crowd, stemming from the Latin word juris for laws, and crowd, to build this data lake, basically. But then it turned out Your Crowd is too complicated, right? If I say you don't know how to write it, if you're also in trademark law, maybe some people listen to this, right? So it's not a great trademark maybe to use Your Crowd. So we said, okay, what's a different brand maybe? So we came to Anita, and it's a historic reference to the first woman in Germany actually having a PhD in law. Got it in Switzerland back then because it was not legal then. But of course, it's also easier to spell Anita and to know how to write it. Though that's kind of the background to Anita, and yeah, we offer a database for legal analytics.
So it means Anita is not an acronym, right? So it stands as a name.
Yeah, it refers to Anita Augsburg, which was the first legal PhD holder as a woman. And yeah, Anita is basically a platform to offer legal analytics, data analysis, and law to answer questions like how often did a court decide in a specific manner with which arguments. And one can also communicate with this database, ask questions, and get answers in natural language, and also create texts with footnote references. That's basically the idea behind it, to integrate the research into the daily work and automate research activities. And with regards to your counter question, are IP lawyers really open? I would say, legal in general is like a conservative field, right? So, but if you look in this conservative field, IP law is kind of the most open that you may find in this conservative area. So even, of course, they're all still conservative, but some are more and some are less. And the tendency is that IP law is less conservative than others, compared, for example, to M&A. I would say. And yeah, what are now the opportunities in this field of law? Your third question.
Yeah, before we come to that, maybe I would like to understand better what Anita is, okay? And so there is a discussion out there that many companies at the moment just create these thin wrappers. Okay, so just a little layer on top of an LLM, and yeah, so to speak, nothing really special. It makes just it easier to work with an LLM. So in your case, first of all, you have very special data. In I would do you? I'm sure you know Notebook LM. So when I use a decision, when I upload a decision to Notebook LM, and then I would like to discuss the decision with Notebook LM. So what is the difference to Anita compared to that approach?
Yes. So first of all, we already sourced like these data, as you said, like specific core decisions, and we also took law firm data to accumulate it. So of course you can upload single decisions to Notebook LLM or try to ask it, please only refer to this web page or something, but you may be unsure if it's working and your data source may be a bit more limited. That's like one difference, but it's not the biggest. I would say the biggest difference is if you work with, you can also use GPT, Perplexity, all these tools, Notebook LLM, they hallucinate to a certain degree. And that's also a problem with these other wrappers. For example, LexisNexis, a very big database company in the United States. We have studies that they hallucinate to 30% with regards to their results. So every third answer contains like hallucinations, and hallucination can mean different things, right? So it can be that there is a misunderstanding of a sentence with regards to the context, but it can also be that a source that is named for as a quote is wrong or doesn't exist, and that creates frustration because as a lawyer, of course, you're liable for what you do, right? And we already see cases in the United States, and we have seen one just this week actually in Germany, where lawyer quote fake court decisions, and then you're in trouble.
Happened in Germany?
Yeah, yeah. It's the first court decision of like a first instance court. And with very drastic words in that, because people tend to rely. I've just also read a study that if normal people work with GPT, only 7% check the quotes, right? But if you start checking the quotes, you realize, okay, there's a lot of stuff. It doesn't really fit to it, right? There's a sentence, but that's not what's written on this webpage. So it's basically made up. And that's what I mean with hallucinations. And we tackle that because our AI that we use is explainable. It's transparent. So we actually know what it's doing. We kind of follow the thought process of the model, and not in a way that is GPT doing it, like showing you little sentences. Okay, now I'm doing this, now I'm doing that. We really follow the neural network. And therefore, we know exactly what's happening, and we can say, okay, this is hallucination, this is not an hallucination. And we can track it back to the original source where the LLM gets its answers from. And we can do this very fast and very cheap, like in instant time and at nearly no cost. And that's what makes us unique, because you can trust our answers, basically. And that's a different level, because a lawyer still needs to check the quotes, but with us, you click on a quote and then you actually have the source, and you can trust that it stems from that and it's not made up, and you're not in trouble.
Yeah, I got you. No, I mean that is a big difference, and I just can say that I'm working a lot with Gemini and ChatGPT and Perplexity, and I had the case that I think it was ChatGPT in that time. I discussed about a book from Marshall Phelps, so the famous former head of IP from IBM, and then from Microsoft, and the book is Burning the Ships. And first of all, I realized that obviously the book is completely known by ChatGPT, which is, from a copyright perspective, an interesting fact. But and then I started to discuss it, and I know the book very well, but it's a long time ago that I read it. And then I had a discussion about open source, and then ChatGPT said this and that comes from Marshall Phelps. What? I can't believe that. And I said, okay, and I have it here behind me in my bookshelf. I have the book, okay, and I said, okay, give me exactly the page where it's that where this is where this quote comes from, and it turned out then finally ChatGPT said, oh, sorry, I think it is not in the book. So what?
Yeah. Yeah, there you see
I
that
mean,
GPT is a people pleaser, right? It tries to give you answers that you may like. It's also a thing if you have like a chat flow, to a certain extent, Gemini will also copy the things you like and will answer where you like, but it will answer to other people differently because it's a people pleaser. Yeah.
yeah, absolutely. But you did not answer to my question that we see this digital transformation. Obviously, I mean, yesterday there was a lawyer on LinkedIn who cited a first page report from a German newspaper about a graphic designer who quit his
Mm.
job because nobody anymore needs his services
Yeah, also
because
seen
that
that.
can, sorry.
I've also seen that. Yeah. Yeah.
Yeah, yeah, wonderful. Okay, and then there was a discussion, and so obviously the digital transformation will hit the legal branch. I mean, that is no question. I like Sebastian Goebel, who is also one of our IP subject matter experts, and I like what he said. He said, okay, IP is about text, and at the end we use text to explain inventions and everything. And the legal profession is a text-oriented profession. So how can we assume that these large language model will have nothing to do with the legal profession? I mean, that is simply extremely unlikely. The question is how, but not if. So when we see the digital transformation, what do you think? Or what is your recommendation? How should IP experts adapt to these developments? What do you think?
Yeah. Yeah, I think what you said is really true. And like for decades, like the legal sector was very reluctant to digital change. Right? We had these rule-based systems, talked about it before, that were able to do what we can do today also, but a bit slower. Right? You had to do a bit more work to also automate text. Maybe, for example, my PhD supervisor, he developed a rule-based system already in the 90s to do contract automation. But back then, people said, come on, not doing it. And there were several reasons because not a lot of people knew about it. So also the clients did not know about it, right? So they did not demand it from the lawyers, and then there was no competition. Still, like I think half a year ago, I talked to a big insolvency law firm, like a very, very big one in Germany, and they said, we don't feel any pressure. Nobody's demanding it. Actually, we make a lot of money. Never made more money than today. But I think this will change now. And that's a reason also why people should adapt, because now AI is a commodity and everyone knows it. Everyone uses it. Maybe not in the workflow, but everyone heard about it. And so clients will demand it, and more law firms will adapt it and also define new pricing schemas, where they're like the billable hours that is known in bigger law firms. It's hard to keep up with that. Because if others can just diminish your pricing, being faster, giving you the same result, then you're just too expensive. So it will probably go to package deals where you say, okay, I can deliver you that in 2 weeks for this price. And you need AI to do this, probably. And therefore, you need also to implement AI in your workflows. It's not just a tool that you use, but it really automates stuff. It gets stuff done, right? So you can lay back to a certain amount. With regards to research, for example, it's like you have a little research assistant. Like in the days back, you may have like a physical one and told that person, okay, please research this task. You have half the day, yeah, and write me a little report. And now it takes 10 minutes to do this, right?
Yeah, yeah.
So that's what I mean with automating stuff in workflows. And it's also a new way of working, so it really changes your life. It's much nicer. You get a freedom, right? It's what humans dreamed of for centuries, I would say, to have this freedom of little workers that get stuff done. We should not be reluctant, but kind of welcome it. But I also agree that for some people it's frightening, and they may be reluctant because of this, because we don't have a clear political vision how to deal with this problem, right? And if you don't have a clear goal, then the market takes control. And for lawyers, it's basically diminishing their existence as a lawyer, and that's frightening, of course. If you don't set the goal then for yourself if the state is not doing it.
Okay, so my take-home message is for the moment that you say that, especially the business aspect of of legal services will change, and this has the potential to change also the market. That is my understanding, and I would say I can agree pretty much on that, and we see that already. So Martin Schweiger from Singapore, he gave a presentation at a Denemeyer event in summer and explained that more or less in the same words as a experienced patent attorney, that he sees that it goes in that direction. And I would say, yeah, and even and especially sooner than later, that happens, simply because there's a certain demand structure. And Bastian West, for example, when it comes to patent drafting, says that the quality becomes better, and so it's not only less work or a different kind of work, but also it is faster, and you work in a different way, and it improves the quality. Yeah, okay, so that is your position on the question how this digitalization and digital tools will change work styles and the kind of work, and also that certain aspects of the work will be completely automized, and done by AI or AI-based agents, for example. So okay, coming back to Anita, it's now your key focus, so to my understanding, is transparency, and this is, by the way, that's an interesting aspect, because this is really my credo. I'm praying that every day, when we try to convince IP experts to become IP subject matter experts at the IP Business Academy. I try to explain these guys that we try to overcome these intransparencies. So which kind of expertise is available and who needs that expertise out there? And I think Anita fits perfectly in that point of intransparency, of this, let's say, legal market, or in this case, legal decisions. So can you explain us, why is it so? What is Anita doing here? And do you have some examples, for example, how this intransparency can be overcome, and at the same time, or in addition, where lie the benefits in this increased transparency from your perspective?
Yes. Yeah, gonna do that. But just to add what you just said with regards to quality, I also just people with whom we work together, they also said without AI, just got like a demand from a client 2 days ago. I could not have answered it in the depth I did in the end if I would not have used AI tools to do that.
Exactly.
So
Yeah.
totally different way of working. And if you're not using these tools, then you don't know what's happening in the society currently. And lawyers have also, especially IP lawyers, if they're working with new technology, they need to understand what's happening to also shape this work and give advice to their clients, right? But as you said, it's also important then to know what the tools are doing, transparency in the end. And we tackle this in like 3 ways. I would say, like, the first thing is that I already talked about is like explainable AI. I mean, if you really want to understand what these tools are doing, if you want to avoid hallucinations, there are many ways of doing it. Like the first thing was RAG, retrieval augmented generation, right? You just limit basically or you try to limit the information that the LLM is using to answer certain questions. For example, you just give the LLM 100 core decisions and tell it, okay, answer this question up in these 100 core decisions. But then you still hope that the LLM will answer the questions up in these core decisions and not up in the data sources it used during its training. But it's a good way. But as we've seen with LexisNexis, still 30% can be hallucinated, even with wrappers focused on specific legal information. And then a second thing is that people try to use LLMs to control LLMs, LLM as a judge. Basically, they ask one LLM, hey, there's the result of this GPT LLM, and now please, Gemini, control GPT and see if the answer was correct, if the quotes are correct and something. But then you use a hallucinating system a non-trustworthy system to control another non-trustworthy system, right? That's a bit weird to do that. So it's unlikely that will solve the problem to 100%. And then we also have the thing rule-based systems in combination with AI, where you basically have like tree diagrams, because I mean, a lot of steps in law, you can break them down in tree diagrams and say, okay, we have these 3 criteria, then you get a patent, for example. I don't know if they're fulfilled. And you can combine this with AI, and we'll say, okay, we have like vague terms, like sufficient, for example. If you want to see what is sufficient, that's a very broad term. But an LLM can try to interpret this term with a legal context. And then you can automate these steps in combination with AI. And then you have a transparent system where you see, okay, it went from this step to this step and came to this conclusion. But still, where the LLM is reasoning, you don't know what it's doing, right? And therefore, we say you need to understand the structure of the model. We need explainable AI, because if you don't know really up in the technical level how the LLM created the answer, it's just guessing. And then you will not get away from the black box. So therefore, we think it's the only solution to come to 100% transparency, just logically. So that's the first thing that we do to tackle transparency. And the second thing is also, as I said, we do data analysis, and we need data to do this. And we combine law firm data with public data sources. So we do data sharing. We give people more data access to get more knowledge, basically. So we support in that way also the state, because normally it's the state, for example, to publish court decisions. And with our way of data sharing, we support the state in transparency as well. And the third and last thing is that we do data analysis up in these data and give people new information they didn't have before, because how legal research was done in the past is that we look on single decisions and then you read another decision and you try to contextualize it. But now with data analysis, we can analyze 1,000 data points at a time, 10,000 data points, and it's a much more sophisticated data analysis and combined with explainable AI, a trustworthy data analysis and not a black box.
Okay, got you. I think I got the point of the explainable AI, which is obviously a buzzword. The question is always, how is it really implemented? And I mean, it's nice that somebody explains it. The question is, do the humans understand the explanation? But okay, I think that point is clear. But my question is a bit, when you look to the public or to users of such a tool, what are the benefits? So I see, okay, it is explainable. You reduce or eliminate the hallucinations, but is it the trustworthiness, so that I say, okay, I can trust now the solution 100%, or are there other benefits which comes out of this characteristic in this case of your tool?
I think the first thing is, I mean, here we are in an IP law area, so we use a patented software ourselves, right? Or several patents that are built up in. And therefore, people can also check, okay, how does it work? And other people checked it's working, right? So we have this patent as a trustworthy sign as well. And that's how you will see it in the platform. It's not integrated as that at the moment, but we can imagine that you have a green color beyond everything that the LLM put out to say, okay, this has been checked, this is trustworthy, for example. So this is the one thing, trustworthiness. But it's also a different experience, because if you would work with Notebook LLM or GPT, you will have the situation that a quote will be made up. And this is kind of irritating and it's frustrating. And you will just not have that, right? So you will just have a better way of using an LLM and getting sufficient results. And that just makes you happy while using it. So it's this trustworthiness from the beginning to build trust, but it's also a nicer way of using a tool.
Okay, got you. So it's more on the level of the user experience, right?
Yeah.
So that you see at a glance. I mean, at the end, it's time consuming to check all these references, and when they are correct, it's boring. And when they are not correct, it is at least annoying. So when I know that I don't have to do that, so when I would do it, it will be right. So why should I do it? And that is the thing where where the user experience starts to become completely different from a system which I cannot trust completely, let's say. Okay, got you. That I mean, when it comes to the usage of AI, especially in a professional environment, so we have lots of concerns. I mean, EP gave a guideline for the usage of AI to their members, so all European patent attorneys, and I mean, for good reasons. We have to think about the ethics, or the ethical challenges when AI is used, in which context ever. It is important that the European Commission says it is important that we know what we're doing here. And I would say for good reasons, at least. So hallucinations are not the only a concern, so to speak, and hallucinations in all of its facets, because typically it's said that this is a bad behavior, but I mean, when you look for creativity, it is wonderful to getting that. And for example, when you use AI for the creation of inventions, so then you like hallucinations, as long as they are physically correct. That could be a very interesting solution of a problem, for example. So I would not say that hallucinations are in principle bad, but for your approach to analyze code decisions and influencing factors, obviously nobody wants to have hallucinations here. But we have also other, let's say, concerns like data leaks, or very specific, now for your case, are biases in the data. So how can we solve that in general, and how is it solved in your case?
Yeah, it's true. I mean, and just to add to what you just said, right? I mean, hallucinations generally can be very good, but in the legal sector, it's very crucial, as you said, that these details are correct. And we had it even before AI, that we had quote hallucinations, so to say, because, for example, we have a famous legal commentary in Germany, which was called Parland, now Grüneberg, and it was famous for having kind of wrong citations here and then, and you already learn it during your legal studies, and that maybe by coincidence or somebody made it up because you wanted to influence the legal scene, but there you already had to check, right? And now with AI, this problem just gets bigger.
Just to jump in here too, I mean, I'm a trained theoretical physicist, okay, and I made my PhD in theoretical physics. And obviously I know what creative citation means. Yeah. So I'm cited many times from very prominent physicists who won the Nobel Prize. Yeah. And one wonderful citation of my work from this guy was that he completely ignored what my paper said. So he cited me. Yeah. So Alex is saying something, and that's it. I mean, he did not anyhow discussed that I say something different from his point. He just cited me. Okay. So yeah, maybe it's not a hallucination, but it is a very creative way to use a citation, and there are other ways to use that too. And I would say that this idea, and this is also what I try to explain to my students. So when we talk about law and working in front of a court, I mean, or a jury and in a court, I mean, what you have to do is to convince people. And convincing people means making arguments. So yes, you have to stand on the ground of certain truth, but at the end, it's an argumentation, and that can be also quite creative how you make your argumentation. And whether it is at the end a fact or not, it has to be convincing to people how you present the facts. And so these 1-to-1 100% transparency it's a kind of buzzword, because law doesn't work in that way, especially not in at courts. And so, especially when you now analysis court decision, especially this bias aspects, I think that is quite interesting. Whether you can find out here certain insights, and also, how do you solve that in your case?
Yeah. I mean, with regards to biases, I think one can differentiate. For example, the first thing is, I think, if a judge, him or herself, has a bias while writing a court decision. And that's tough to analyze because you need all these data that may have influenced the decision in a digital form to do it automatically with an analysis. Or you would do like a questionnaire or something. If you just have a court decision, I mean, a judge is intelligent enough or may not even realize that he or she is biased and just write a court decision and just writes in it what may be reasonable by law. But just ignores other factors. And if that's the case, you cannot find biases by just analyzing court decisions, right? So that's a very, very tough thing. And we see a lot of also, I would say, bullshit bingo science in that regard. We had like a multiple times cited study that judges may rule harsher when they've not eaten, when they're hungry from the United States. But turns out we're not able to reproduce this study. Yeah, there was a German scientist, Sparmann. He was a guest researcher at Humboldt University. He tried to do it, was not able to do it. And he did it with several other empirical legal research studies in that area. So there's a lot of bullshit happening. So one has to be very, very reluctant with what one thinks one can argue based upon the data.
At least careful.
Yeah. Very, very careful. And the second thing, of course, is a bias with regards to the data source that you have. For example, if we have in Germany, we have 1.6 million court decisions publicly available, like roundabout. But that's not all these data. So there may be data points missing. So if I make an assumption based upon these data, it may be wrong with regards to reality because I don't see the whole reality, because I don't have all these data points already with the court decisions. But still, we use these court decisions at the moment to build argumentation. People read it, do qualitative analysis, and they don't have more than that. So the system is already biased in this. So we're kind of used to do legal analysis in this bias system. And then if you automate the system, that's not as bad. Yeah. And we try to limit this bias by getting more data from law firms, for example.
Yeah,
But you have to be careful.
what I could imagine, to my understanding or my experience with court decisions, for example, in the case of standard essential patents in the mobile world. So what I think what a system like yours could really nicely be used is to understand the change of the argumentations over the time. That in the early days of SEP decisions or the Orange Book time, these decisions were argumented in a different way compared to what we see today, simply because Friend is developed more and more industries are affected of mobile communication or interoperability in general. And so what I would think is that you can see that change in the argumentations, that and you see the more differentiated arguments which are used there. Is that correct?
Yeah, that's definitely correct. And that's also something we are proud of because we go very deep in the analysis of court decisions and we analyze the argumentation. So we structure every court decision in its argumentative structure. And then that enables us to compare arguments over time through court decisions for specific cases. You can do a lot of stuff there. And it's actually the first time that we can now empirically measure legal opinions in that way, because there's also, I mean, legal, as you said, it's an art of convincing people. So it's not always logic, but it's also power arguments are used. For example, okay, this court said that, and it's a higher court than that, so the other one is just wrong, not because it's logic, just because it is like this. The other court has more power, because and now we can really analyze: is that really true? Because there's not only power if a higher court says something, but also if 100 courts said something and one court says something different, right? And the one is mainstream, and legal is used to follow the mainstream opinion. And then you can really say, okay, is that a mainstream opinion, or did it change over time, as you said?
And something which I have certain experience with is the problem that sometimes in IP you have, so to speak, interdisciplinary problems. So, for example, when it comes to patent infringement, then you have not only a legal argumentation, especially that when it comes to damage, there is an interference between, and also in friend discussions, you have an economical point of view and you have a legal point of view. And Judex non calculat, you have the problem that I mean, the challenge that somebody who is a judge and is trained and well experienced in law has typically not really a fundamental understanding of economics. So what defines a market and what does not define a market? And can a company change a price simply because they have to pay a higher license? Or would this change of the price ultimately mean that they lose market share, or they have to go out of the market because of the price is too high, and all of that kind of discussions, which are basically economic or management orientated, microeconomics, and are not primarily legal. But these I mean, IP is an exclusive right, an exclusion right, a forbidding right, and it is used to get certain economic advantages. So in many of these discussions, we have an interdisciplinary approach, and I personally have seen that quite often, that judges do not really follow rational economic argumentations. And that is also something which I would assume is very interesting to follow that on your system, simply to understand how certain decisions are made without a full rational economic argumentation. We simply have to take that into account, that can happen, and it doesn't help that your witness or the management of the company says this is unrational or not economic thinking. I mean, the judge tells you what this decision is.
Yeah, that's right. We are able now to really see which court is more likely maybe to follow a certain way of argumentation or accept certain arguments from the parties, at least if they're visible in these data that we have. And then you have certain kinds of courts or judges. And of course, it's limited to the data that we have. It may be different. Maybe we have like a biased data source, as I said before. So it's coincidence, and we find, okay, they don't have economic understanding, but it's just our view because we just have these data that we analyzed where it is present. But it may be different if we would have all court decisions. But that's something that we can check now. And also make it visible to the judges and the courts, and that's maybe also a benefit for them. Because they see, actually, there's a point. Maybe we should reflect what we're doing or what we're not doing.
Yeah. I mean, in research, we always use data which we have simply, or which we can collect. I mean, obviously, we would like to have more data. Yeah, as I said, as a physicist, we would really like to have a laboratory in which we can put the sun in. Yeah, that would be a quite big laboratory, but it would be extremely fascinating. Okay, to make some jokes with the sun and to look how it's react. But unfortunately, it's not given to us, so we just can observe what it's doing from far away, and so we have to take the data which we have. And I would say our starting point for the discussion was how is the digital transformation affecting the legal profession. And I think that what comes out, that we have now the opportunity with such a system and such a logic to analyze court decisions. That is really a fascinating opportunity. So thank you very much for explaining that to us. Our time for today is over. And to all of you out there, we are happy to work with you as IP subject matter experts at the IP Business Academy. We are open to applications. We are happy to work with you and with the especially European users of the IP system. So a direct message on LinkedIn is enough, and we get in contact with you. Til, thank you very much for taking the time to explain us that, and I'm happy to see you now in the after show party on LinkedIn, and that we can answer to the comments and questions from the audience. So to you and to the audience, bye-bye.
Yes, also, thank you very much, Alex.